I think neither of us expected the other one to be there. Rating.
For HOA.
Before we get started, we have our sponsors there for the panel, so she's going to first discuss the. Hi everyone, my name is Natasha Salvaraj. I am a real estate attorney in Burlington. Thank you. We are one of the sponsors today, so thank you for having us. Thank you all for being here. I know we all love associations, right? They're so fun. So you'll hear lots from me on the panel as we talk about all kinds of fun things related to associations and how they impact our transaction. But for those of you who are not familiar with Burlington Ebling, we are a full-service law firm. We have 5 office locations. We go from down south in Venice all the way up to the Tampa and St. Pete area. So we have offices down the West Coast and can handle your real estate transactions anywhere in that area. We are a law firm, so every transaction does get a real estate attorney assigned to it, and that way your clients and you have legal representation, and you'll hear some of my thoughts on why that's important when you're working in contracts with associations when we get to it in the panel. Charlotte, who is one of our business development directors, is in the back collecting business cards because we do have a raffle that we'll draw a card for at the end of the panel and before the wine and cheese reception. I hope you guys can stay for that. Nice opportunity to continue the discussion if there's any unanswered questions, but also for us to continue to talk about maybe other specific issues you have that we don't get to, or any questions you think of that we don't get to. I know every time we've talked about this panel, I've started making, when we first talked about this panel on the Professional Development Committee, I started making notes of weird and unusual HOA or condo related questions that we've come across on transactions. And the list continues to grow. So I'm sure there'll be plenty to talk about. I was talking to someone earlier today, and as I was driving here, I got a call with a fun new situation. So always something new to learn. I appreciate that you're all here and willing to take the time to learn and invest in your education and that future representation of both your buyers and sellers. So thank you.
I love that. Don't go too far, Natasha, because we are going to introduce our panelists. And since you already have a microphone, why don't you tell them who you are? You did say that before, but give them a fun fact about you too.
A fun fact about me is that I'm Canadian and I moved here from Toronto, Canada. So if you do have Canadian buyers or sellers, for some reason they seem to appreciate that. So if they need a fellow Canadian, I'm always available.
Thank you. All right, and then Katie.
Hi, Katie Cintron. I'm with Coldwell Banker Realty on Siesta Key. I do both residential and commercial. I also serve on the leadership committee here at RAISM, and I'm have been on numerous committees. I'm a district director here for RAISM, Florida Realtors, and I enjoy working on committees here and networking with all the members.
And I'm Brooks Beauchamp. I work for Coldwell Banker Sunstar, and all I do are rentals and property management.
That's not all you do. That might be like, when you say that's all I do, you make it sound like that's not very much.
It's way more than you ever want to know.
Oh, I know, because we manage 400 doors at my company too. So it is property management, working with HOAs. That's something that we get a lot of evidence or a lot of work with. I'm Alex Crum. I will be moderating the panel here for you today. I'm the broker owner at Next Home Excellence up the street. And I am here with you guys today at one of my favorite places because I love it, at the Realtor Association of Sarasota and Manatee. Those of you who've been with me here in the past know that's absolutely true. I think it's one of the greatest places anywhere to learn more about this business. And that's what we're going to get to today. So over the course of today's panel I want to make sure for you guys that it's very conversational. If you guys have a question, I would love to hear from you guys. I'm sure our panel would as well. We have lots of great questions that we're going to go through, covering things like due diligence. What can you do as realtors to work with associations to prepare so you don't run into some of those snags up the road? I have always found that when working with HOAs, when working with condo associations in particular, that proactivity is much better than reactivity. Get in front of it. We're going to talk about making sure that you guys have appropriate coverage in your contracts, how that can affect different financing for you. And then we're going to get into some of the nuts and the bolts of the associations themselves so you guys can understand how those things work kind of legally. Does that sound like a good time? Every one of you just lied to me. Just kidding. I have great news for you, though. It is a Monday afternoon. There are so many of you here. This is a great turnout, by the way, for a Monday, and I appreciate it. I'm going to pretend that has nothing to do with the wine and cheese that is coming after. So when we hang out, do hang out with us after the conclusion of the panel because it is going to be worth it. Courtesy, I think, Berlin, Pat, and Ebling. I love it. All right, so let's start. So we are aware that when we are working with some associations, that there is some required documentation before you actually go under contract. And I think that probably the best place for us to start with this, Natasha, is with you. What is a best practice for ensuring that a buyer receives documentation required under the contract?
My number one recommendation is to make sure that it gets emailed to the buyer's agent. With an email, you have a receipt that you actually sent it. Email delivery rules are based on you sending it, not necessarily the person receiving it. Although if you get a bounce back, you have to be honest and actually send it to the right spot. I've had people who are like, yeah, but I sent it. I'm like, well, you sent it to the wrong place. Doesn't really count. But make sure you do that. I know a common question is, well, I put everything in the MLS. They can just download it. Which, yes, they could, but that requires that the person that you're working with be as diligent as you and actually know where to see them and download everything. And you don't really want to be in a battle of who uploaded it when and when did it get downloaded and did everything get downloaded. If you attach everything to an email and say, here you are, you have that record so you know that you're protecting your seller from someone saying that they didn't get something timely. And from the buyer's side, I know buyers like their little 3-day condo review period to get out of the contract if something comes up for whatever reason and they blame it on the condo. Sometimes it is the condo, but starting that window early helps. And if you're representing a buyer, you don't want to spend all of your time and energy working with a buyer on a unit that you know that they're not going to buy, because when they read the rules and find out that they can't have their truck or their dog or can't have hardwood floors and have to have carpet or whatever the rule is that's going to be a problem, that after all your hard work, they're going to cancel then, when you could have just looked at that on day one and moved on, or even before you put in an offer and moved on. So just making sure that you get those and document it early. I like email for that because you can keep that record. It's easy to save to your file. No one can tell you later. And it's the same when you forward it on to your client. You don't want a buyer to say, oh, you never sent me that, because they only text you and you sent it to them as an attachment in a text message, and now who knows where that is. So just try to get that. If they like text, send them a follow-up that says it's in your inbox or whatever it takes so that they see it, but make sure that you're also protecting yourself, because unfortunately, we are all the first people to blame when something doesn't go the way that a buyer or seller wants, and what you can do to protect yourself is always going to be important too.
All right, so thank you. So Katie, then, if we are listing agents, can you guys hear me in the back, by the way? Okay, good. So if we are listing agents and we're working for a property, we talk about the condo docs. Those are outlined specifically on your condo rider. You have the declaration of condo, you have the budget, you have any of the restrictions, the rules and regulations, required documents. Those don't necessarily exist for the single families. However, it's possible also that your customer is interested in understanding what they can and cannot do with the property once they have purchased, whether including can they lease the property, which is one that we've run into multiple times. They might want to Airbnb the property. They might want to have an ancillary dwelling unit, like I was talking about with this gentleman earlier. What is the best practice if we know from a customer that they have specific needs for us to make sure that they're covered, Katie?
Well, the first thing I do is I make sure that they have a copy of the rules and regs, the financial reserves, the declaration of condominium, and just me personally, I try to get a copy of the recent minutes in case something is not recorded. They'll know what may be coming up available in the community. Sometimes I go back even 6 months so they can read them. And again, I email everything so that they have a copy. I have a copy that I did send them, and they have received them.
Thank you. So, all right, well, that's wonderful. So how would you go about, and Brooks, we'll just move down the line, and then I'm going to switch it up so you guys don't know what's coming next. But in the event that you are getting ready to list a property for sale and you need to get some of the documentation together to be able to provide for the buyer, where's the best place to get that from? For instance, one of the ways that I've seen a lot of agents do that over the years is that they go in the MLS, they look for a recently sold or sometimes just a sold listing, and they find a little one that's got the paper clip. You guys know the paper clip at the top? Right, because that's where you often find those things. True or false, that's a good idea to get things like condo docs and budgets.
I try to put as many documents in there to make it easier on me, and if I'm the listing agent or for the buyer's agent as well, like the application to purchase and things like that. But always, like I said, have that paper trail. Make sure that your documents are current and that you email them to the buyer's agent if you're the listing agent, and then it's their responsibility to provide it to their buyers.
Right, but as the listing agent, to get that documentation in the first place that we upload there,
I always go to, if I'm the listing agent, I will go to the seller, but I will also go to the management company as well. I've ran into problems where what the seller provided me wasn't up to date, so I definitely go through the management company as well, cover both ways.
Adding to that, the owners usually don't have any of the current information. They don't know anything, but also the CAMs at the HOAs and the condo associations, you're really not supposed to go to them for these things. And they really don't like it at all. But then we have the sellers that don't know anything either.
right, and so all of a sudden there's no real, it's hard to get the source there.
A lot of times now you can go to websites. A lot of them are still password protected, but you can find the rules and regs and all that.
All right, so, but maybe the owner could go there and provide those for us?
They need to.
They need to. It needs to come
They're-
from the owner?
Yes.
Yes, all right. I love that. I like getting them from the owners myself personally. I think that's important. Or directly from the association if they're friendly. If they're friendly. All right. So now what do we have is, like, let's just say, for instance, that we feel as a buyer that an HOA or a condo association might be overstepping its authority, or we have a question that the buyer poses to us. Is this something that we can or can't do with our property? Is that something that realtors should be covering? And if so, or if not, why or why not? I don't mean to make it sound like a test.
Well, I think that's kind of a gray area. You wanna be careful. I would try to talk to another person trusted in the community, or maybe I know someone that has sold a lot in the community and has a good background of the community and their rules and regs or whatever the concern is.
Good. We're good. All right. Thank you. Let's talk a little bit about milestone reports. Since we are focusing so much on condos, are you guys aware of milestone reports, what they are? So this is any condo that is within, I think, 3 miles of the water, that is 3 stories or higher and is older. Is it 25 or 30 years? 30.
But then SERS is, yes, you have to do a milestone inspection every 10. Milestone inspection is every 10 years, starting year 25 or 30, I can't recall. I think starting year 30, and then the SERS report is at year 30, and then after that, you'll do a milestone report every 10 years.
And why do we get those reports?
Well, in case you, that's a fun question. So as I'm sure everybody's aware, we had a significant condo collapse in Miami not long ago. And the result of that was the realization that there's not really any oversight on condos after their initial construction. So I do some new condo development. So I'm very familiar with the beginning process where there's tons of inspections, there's oversight on documents, there's people reviewing my condo declaration before I can have anyone sign it, before we can close, making sure all the rules are reasonable and things like that. And then you close and they're like, okay, go about your day now. And then older buildings, some, for example, 30, 50 years old, have had the same rules and had the same regulations, probably didn't really contemplate any type of inspection. There was language in the statute that let a developer and then condo association boards waive reserves. And so as a result, buildings weren't very well funded, and everybody's thought process was, yeah, we'll fix it when we need to, and we don't need all this money sitting here. We'll just do a special assessment when we need to fix something, and that'll be whoever's problem it is when they're living here to fix it. Which sounds great until you knock on everybody's door and tell them you need $100,000 each, and everyone's like, "What do you mean?" So really now these inspections and these reporting requirements are in place to ensure, supposed to be ensuring public safety and well-being over time, and to ensure that people who are buying into condos can trust the, I guess, structural integrity of these buildings. Because if you think about it, that's not something anybody inspects when you're buying a condo in Florida. I've had one person do it ever prior to Surfside, and he was from New York, and it's a standard practice in their high-rise buildings, especially the older ones. But in Florida, you inspect the inside of your unit and you kind of move on, and everybody was relying on the condo association somehow taking care of all of this, but nobody stopped to think, wait, who in the association is taking care of it? Is it our voluntary board who maybe doesn't have anyone with the necessary skill set? Do we have an engineer who's reviewing an engineering report? Do we have someone who really understands, building code? You don't. You might have someone who's like, oh yeah, I was, I don't know, a teacher or a lawyer, and now I'm here and I can read the documents and I can follow the rules, but I can't read the report. And so these reports are all really hoping to create long-term stability in the condo market. But as we've seen, not so great to buy a condo right now. Everybody's a little worried about those special assessments. And so really those are there for safety and public policy reasons, but obviously the rollout hasn't been quite what we expected or anticipated. But the intention is to make sure that people are getting accurate information about what they're buying, since you're not necessarily buying a single family home where you can control everything, where if you need a foundation repair, that's a decision you make and you can undertake and pay for and finance, versus a condo where it impacts the whole building and not everyone has that same information.
Yes, please.
And anything over 10K. So that's another 3 things.
And that can cause those fees on a monthly or a quarterly basis, however they're being assessed. Those can go up, in some cases, dramatically higher, because now we're funding not just repairs, but reserves at the same time. And a buyer might want to know how much their outlay, their carrying costs are going to be for that. Does that make sense?
Yeah. All 3 of those, and special assessments, and also assessments on top of that for insurance costs that have gone way up.
Absolutely. Yeah, that's it. We had a question. I'm happy to take questions as we go. I am going to repeat it back for the microphone since we're repeating it. I'm not just going to be weird. I'm going to repeat it, and I'll let you know in advance.
Is there anything I can heads up for, or
All right. All right, so let me just repeat the question just for the recording. The question is that you have a specific case in which there is a condo association that just had brand new roofs put on, and so as a result, they have chosen to short, at least for the rest of this year, their reserves. And your question is that going to affect funding or the financeability of a purchase there because of shorted reserves? Is that accurate? And anything else that you should be aware of as far as a property that is not currently funding for a new roof? Yes, Brooks.
they can put that in over a certain period of years. So when it comes up again, they will have. So it's definitely shorted to avoid that. Well, but they did take out a large amount based on that. So that's what they were paying off house roof and also like having to put like more in it. You know, okay, right, but, I just don't. Yeah, I'm not.
I think the short answer to your question about the short answer to your question about financing is it's going to depend on what type of loan the buyer is getting. A lot of lenders are going to be able to work with that and say, okay, well, they just got a new roof. They have all this money in financing. They're going to have to pay it back, but their financials look like they're going to be in a good position to do that because despite that, they're collecting all of this other money for reserves and have all of this other money. So generally, you probably will be okay. They don't necessarily have to have all of the money constantly, if that makes sense. And I believe it's probably an accounting question, and I'm not an accountant, so take this with a grain of salt. But I'm pretty sure that even though on their budget they have to show each line item of what they're saving for, as long as they have the total amount, I think that they're okay. They're not going to say, oh, well, you really should have had $105 in the roof budget and you only have 102, so you failed a test. It's going to look at that total as well.
And I think also it comes down to, correct me if I'm wrong, that's when you're talking about the milestones, it's really more of a legal requirement of the association than it is about lending for the particular property, because the associations themselves don't really have a choice. They have some flexibility that's built into it in terms of the amounts that they have to keep up, but they do have to keep up with major things like roofs that has to be accounted for. But I think the lender is more concerned with solvency. I can speak to that. Anybody who would like to speak to it, though? All right. I think that one of the things that I would look at would be escalating costs. Because anytime that you have something that you know is going to affect the property, that is going to increase the cost. For instance, we closed at my company a property just 2 weeks ago, a condo complex that was affected by one of the storms. And as a result, they had to put a pretty large assessment in place on that home. That was something that nobody had anticipated. But it affected our real estate transaction. That's affecting real estate transactions all over the state, always does. And so what I would be looking at primarily is to say, you know, how much do we expect it to go up once you reassess and you do start including for that roof? And where would be a good question? Where would we place it? Where would we pose such a question to, guys?
At your meeting. So bring it to your meeting of the board, ask the question, it'll be on your minutes. If they don't have an answer, they'll be able to get one. And usually it's a good time to bring these things up because you're going to have other owners who haven't really thought about it, who are then going to go, oh yeah, that's a really good question. I do care about that. And so that's an excellent place to do that. And that's also one of the reasons that I encourage people to get meeting minutes. So the condo rider does require it. And in the special assessment section, on the condo rider specifically, it says that if anything has been discussed in the meeting minutes for the last 12 months, that the seller needs to disclose it. So make sure you're looking at those, because if something has been discussed as potentially being an assessment, you want them to be able to disclose that and not get into the potential liability for paying that assessment in the future. Just hand them over. And that's a good question, because a lot of times people are looking for you to maybe spoon feed them the information, but all you need to do is provide them with the information. The reason I say that is that things that might be important to you and me might not be the things that are important to the buyer. It might be the sentence underlined what right after what we highlighted or underlined that might be what they care about. For example, I don't have pets. So when I review a condo declaration, I'm not looking to see what the pet restrictions are because it doesn't impact me. But I know that there's a lot of people where they don't care about the stuff that I might look for. They care about, can I have both my dogs or all three of my dogs or my pet horse or whoever else is coming to live with them? And so I think it's really, really important to make sure you're giving people that information, but also empowering them to review and make those decisions. You can answer specific questions, but you don't want to fall into the trap. And I've seen this before, where you tell them the stuff that you think is important, so they go based off of that. And then 2 or 3 weeks later, the world is ending because never did it come up that they had a pet iguana and now they can't have their iguana, and they think that you should have told them that. And you're like, but I didn't know you had an iguana. How would I know that? Never came up. But once you start giving people a lot of information, they assume that you know a lot about them that you might not. So you just want to be careful about what information you're giving and how you're presenting it, so that way they still have access to it and they don't feel like you're steering them away from something that, you know, could be relevant to them, and they might not notice because you highlighted over here and they're like, oh, well, I only read the highlighted parts, when obviously you were just trying to highlight that and not tell them not to read the rest. So just be careful about that.
Love that. We had another question. I'm going to come you first, and then sorry, and then right behind. Yes. All right, so to repeat the question just for the recording, what happens if you as a realtor or as an owner in the community, as a seller, is aware because you heard something at a board meeting, but it never actually made it into the minutes? Do you have an obligation to disclose? Is that the question? All right.
My very lawyer answer is yes, please disclose. We run into that more often than you'd think, because you maybe have some sellers who are board members, so they just know information that other people don't know yet. And unfortunately, that doesn't mean that they can pretend that they don't know it when they're in their shoes as a seller. They still have that knowledge. So if you have knowledge of something, you do have to disclose it. And I have found in my experience that when someone says, I don't think I want to tell them, it's probably because they know it's going to negatively impact the property. No one wants to not disclose something that's going to be beneficial to the buyer. And so I always say that lends additional support for why you should disclose, because eventually they'll find out, and then it's going to be, oh, well, you didn't disclose because you knew that it was going to dissuade buyers from buying or impact the value of the property or whatever that might be. And the standard for disclosure in Florida is it's Johnson v. Davis, which is if it's readily observable, a seller doesn't have to disclose. But if it's not readily knowable or observable, then a seller has to disclose. So anything that a seller knows from living in a property that a buyer just wouldn't be able to tell by walking by, they're going to have to disclose, and that's going to be the standard that they're held to if it gets discovered after closing. So it's not a let me run out my clock and see if we can close and then I'll be free. That liability continues. So I always encourage people to disclose information that they have.
So all right. So let me kind of phrase it. All right, so let's just make something up, that you are in a condo community and you just understand, everybody's aware that this condo community is built on top of a sinkhole that is also filled with poisonous snakes. Now, we're aware that that's something that we might want to disclose, but now there are whispers in the hallway or even at a board meeting in which we are saying, well, we're finally going to take care of that. We've got a guy, but it's not cheap to fill this sinkhole and remove the snakes. That's pretty specialized. And so there's conversation about that. There may even have been some quotes that were received or something like that to do that work. But It doesn't reflect in the minutes. There's not a motion on the table to increase, to cover, or to do anything that has to do with the increasing the assessment or placing a special assessment. Is that in line with the question that you're asking? Close enough? Close enough. What do you guys think? You're going to get sued. Who's going to? They're going to get sued for not disclosing? Yeah. Mm-hmm. Mm-hmm. I guess the real question is it a disclosable item? Is it a mandatory disclosure if we're aware, but it's not in the minutes? Is that right?
My answer is it's probably going to depend on what the thing is too. If, for example, we have a sinkhole and snakes, we might want to say, you know, everybody could see it. You have to drive right by it to come in. I don't have to tell you that it's there. If you're talking about we have quotes because we need to fix the elevator because we know that at any given moment someone's going to get in that elevator and the entire thing's going to come crashing down and everybody's talking about it. I think if you know that, it doesn't hurt to share it, because I've never seen a seller sued for sharing too much information. And most of the time we can overcome that. So it might not be something that needs to go on the rider because there's no special assessment coming to it. It's just a conversation. There's nothing that anybody can do about it. It's more informational. So maybe the appropriate spot is a realtor remarks. So that way they're aware of it. And if you have a buyer that you know is terrified of snakes, then maybe they don't go to that neighborhood because they're like, you know, that's probably not the right spot for me. But if you have someone who's like, oh, it doesn't bother me, this might be a good opportunity, then, you know, you're also pre-vetting someone who's going to waste your time, because if it's not going to work, it's not going to work.
So I think, so just to follow up on your question and this answer, which was the exceptional answers, is that if you place the customer as the North Star and you say, what's best for the buyer in this case? Because ultimately it's going to be the buyer who gets that property, hopefully, if everything works out. We want it to work out. We don't want that person to get in there and then realize that all of a sudden they can't afford it because now the assessments, they spent everything they had to get in here and now they owe an additional $15,000 cash due in the next 3 months. Nobody wants that. Is it right for the buyer? Is it wrong for the buyer? And so the question then comes, I think it really comes down to, like Natasha said, it is easier to overcome too much disclosure than not enough. If you don't disclose, if you don't let that happen, then I think you might run abreast of some legal issues, but you're also going to run abreast of some transparency issues. And if you lose a buyer's trust, you're probably going to lose the transaction. It's going to find a way to fail somewhere in there. But as long as everybody's on the same page and moving in the same direction, and that happens through strong communication, that's where I think those properties are going to be more likely to close more often, and also where buyers end up in better situations for buyers and sellers in better situations for sellers too. Does that make sense? I love it. We had another question behind. Yes. I love that. That's actually on my list to ask. All right. So your question again is, what if you have a community that is not very communicative or that refuses to work with you, the sales agent, to get the docs required for the transfer? Is that right? I love that. What resources are available? Well, we have a CAM with us here today. And you smile a lot. That's kind of unusual for a CAM. No offense to CAMs in the room.
I'm a realtor and a CAM.
Yeah. Good. So does the CAM have the obligation to work with the realtor in the first place? Who is the CAM's client?
No.
Homeowner, the seller.
The CAM works for the seller?
That because even in rental land, I have trouble with some of the associations.
Mhm.
I don't know a good answer for that. They need to.
They need to provide, it needs to be provided.
Again, I always look online and, pardon me?
Do you have an answer?
Google it. No, that,
So all the condo documents are recorded in the public record, so you can find all of the declaration, rules and regulations, any amendments in the public records by searching the condo name. Your closing agent can also retrieve them because we'll have access to that through our title underwriters too. The things that you're not going to get, special assessments and updated budget, because they're not obligated to record those every year. Those documents, unfortunately, are going to have to come from the association. So one thing that you can do is you can, again, have your closing agent request it from the association when we request the estoppel. Unfortunately, they like to charge us a lot of money for that. So it's important to make sure that your sellers exhausted the other options because they don't want to see a $500 charge for getting a copy of the budget. I hate to put it on there, but that's sometimes what the association charges. But typically, the association has an obligation to provide copies of documents to all owners. The statute tells them how long they have to provide it. They have to provide them with copies or the ability to copy within a reasonable period of time during business hours. There's all these little requirements. I have unfortunately had someone hire our office because their association wouldn't cooperate and they need an attorney to send a letter. But typically it doesn't get to that point. Typically you can get them, but sometimes it requires like work. It might mean your seller has to go to the office and be willing to take the documents and copy them or pay a copy fee. Sometimes they don't want you to actually copy them. They want to do it for you and have them for pickup. But almost everything is in the public records except for the financial information. So that's something that you'll have to request from them.
Right. And so one of the things to look at there that I'm hearing is let your seller be an active participant in the transaction as well. It's one thing to take everything on that we can, but we are going to incur costs if we go after those. And that's going to happen in almost every case, in my experience, when working with communities. But sellers can often get those things by themselves, often for nothing and with less headache. I will say I understand and I feel your pain in terms of uncooperative associations. I've been there. But it is also at the same time, they do have an obligation to provide those not to the sales agents, they do, not to the landlord, or not to the property managers, but they do have to get them to the association, to the residents of the association. That's core to their job. Okay, yes. Yeah. I like that answer. That's a great answer. Sit there because you're providing both customer service and getting them directly from the source, from the association website itself, usually held at a website that is maintained by the association management company. So that's a great answer. Thank you.
Motivate sellers when you tell them that there's going to be a cost. Suddenly they remember how to use their email and their phone when they realize that otherwise there'll be a bill. But it also helps to remind them with the condo rider on a condo contract, the buyer has 3 days from whenever they eventually provide those documents to cancel. So if you don't get them to me until closing, I can cancel at the closing table. So the sooner you get me my documents, the sooner you know that I, as the buyer, am locked in. And hopefully nobody wants that more than the seller because I'd like to believe that they want to be in that contract. And usually that helps motivate them to take that step. And if the answer is they really can't find it and we need to pay for them, we can. But I have found that sometimes that little extra motivation helps.
I love it. You guys are a rowdy side of the room. I love it. Continue asking your questions. We have time for like one or two more over here. You guys got to catch up on this side of the room. We're going to go here and here, and then we're going to move on.
So, Natasha, what's the time lag? Two-part question. What's the time lag from when a condo association adopts something and when it has to be registered? That's one question. Second question is, aren't there certain like rules and regulations or certain things that aren't required to be registered that they could be passing as well?
Yeah.
So the question there, two parts, just to say it for the recording, is that number one, if something passes, if a motion passes, it's going to carry something like a special assessment, how long do they have to register it? Is that correct? Yeah. And two part, are there items that might be relevant to a buyer, but that don't actually get recorded, and they're not required to be registered either in the minutes or in documentation notification.
So most things don't have to be recorded. So getting accurate records from the association is going to be important. Any amendments to the declaration have to be recorded. They require, typically, it varies by association, but somewhere between 70 to 80% of people have to vote and approve. You'll see them recorded, and it's going to be like a 50-page document. Most of the pages are going to be signature pages because they have to show everybody signed. But any amendments to rules and regulations, any amendments related to special assessments and budget, none of that stuff gets recorded in the public record. So that's all stuff that you're going to have to request from the management company, or if you're working with a smaller association, from the board. Those will all be basically stored internally, which is why I always recommend making sure your seller is paying attention to getting the most updated information, because I've had sellers swear to me that their 2001 budget is accurate. And I'm like, we're in 2025. I promise you it's not. There's no possible way. And if it is, I want to know who's providing all your services, because I'd like some 2001 pricing too. But just make sure that you're getting that from the association, because a lot of the stuff, to your point, that is going to impact the buyer is not recorded. So that's going to be the stuff that we want to make sure we have updated. Generally, if something does need to be recorded, it's going to be something that the association's attorney's preparing, and it'll typically get recorded within a couple of days of it happening, because like most attorneys, we now can do everything electronically. So it's, you go from the meeting, scan, record, so nothing gets missed, and you keep that gap closed. But the requirement is only condominium declaration amendments. So rules and regulations don't have to be recorded.
Yeah, what's the timeline?
There's not an actual requirement for when it has to get recorded. Typically, most people record within the week, just because you want it to be timely. You could record technically. Your document's still legal if you record it a year later, but most people try to record fairly quickly. There's unfortunately not a requirement in the statute.
Yeah, so back to the risk, I guess I'm just saying is that you got stuff that doesn't have to be recorded, then you got stuff that doesn't have to be recorded until a year from when it passed. So it really is important to get a cooperative association if you're trying to represent the interests of your.
It is very helpful to have a helpful association. Sometimes that's asking a lot. Again, no offense to any of the association managers in the room.
Buyer of the risks they're stepping into when you don't have a cooperative person. They
Yeah.
need to be aware.
That's it. And that's that element of risk. And there is some caveat emptor, some buyer beware, where the buyer does also have to be that active participant in their transaction. We had another question? And then we're going to move on. Yes. Thank you. You're actually asking my next question, which I love. It's like you got the script. So the question is, we've been talking about primarily condo associations to this point. And I think at this point, all of us are aware that with condo associations, you have to provide declaration of condo. You have to provide the restrictions, the rules and regulations, the budgets. My question for the panel, whoever would like to kick in, is there a similar requirement for HOAs?
There is not. The HOA disclosure is just a paragraph that tells you that you're in an HOA, so there are rules and there's payments that are due, and you should read them. It's pretty much the summary, but there's a summary. It's in bold. All the Homeowners Association statute requires is that bold paragraph be included, and basically that's what it says. This property is part of a homeowners association, so you're going to be subject to any of the restrictive covenants, rules, and restrictions of this association and this subdivision. And then there's a little spot where you put in whether there's quarterly, annual, or monthly dues, what they are. It tells you that it's mandatory, and then there's a box that you can check, I think, for whether or not association approval is required or not. But so the homeowner association requirements are not the same in terms of you have to gather all these documents and get them to the buyer. So that's something to keep in mind as well, because depending on what neighborhood you're buying in, you might have buyers who are like, wait, but I do want to read those, and I do want to make sure I can, do what I want to do or what I'm anticipating being able to do on the property that I'm buying.
I love it. Can I just, so go ahead, Brooks.
So with HOAs, it is like condos, and a lot of them have sales applications, just like a rental application for the association. And again, if you're a buyer, I'd want to know everything and get all the documentation and the rules and regs. Just buyer beware type thing.
Just buyer beware.
Yeah.
So how can we cover ourselves? If we're working with a buyer and we know that our buyer they've got a specific use. They want to rent it out, or they've got
A trailer.
3 giraffes, just to
Right.
be, we're just on a jungle theme here today. What do you do
Read
you
the
do to cover your buyer?
documents. You have to read the documents.
You have to read the documents. No, do you guys want to handle that?
Sure. So there's nothing wrong with putting it in the contract. If you want to make the contract contingent on receipt of any particular document or documents, you absolutely can do that. The seller then will have the obligation to do that. And anything you write into your additional terms is going to override any terms of the contract or the riders that are pre-printed. So to the extent that you do want to make it contingent on the seller, similar to a condo situation, providing all those documents, you can write that in. If you want to put in a window for review, you can write that in. When I say you can write it in, I recommend that you have an attorney draft your additional terms so you're not practicing law, but you might have standard language that you're copying and pasting, and that's fine too. So there's nothing that prevents you from doing that, and we do see that fairly often where people will make it contingent on specific things. For example, emotional support animals. I often see people write into their contracts that the contract is contingent on an emotional support animal being approved to live in a building because they haven't seen the rules and regulations yet. They don't know what the application process might be like for a particular association, and they know that they're not going to buy this condo or single family home and move in if they can't have their emotional support animal. So you can do that and work to craft. All our contracts are standard contracts that are supposed to cover the most basic situation and apply broadly, but you're always going to have situations that require something more tailored and more detailed. And I like to believe that's why we have so many lines at the end of the contract for additional terms where you can draft something that's specific to your situation and what you need. And if you ever have questions, I'm always happy to help draft language and give you the language that you need for your contracts.
So for my managers on the panel, have you guys ever had a situation, I'm sure you would have never gotten yourselves into this, but maybe you had a property referred to you for property management, but the owner wasn't allowed to rent it? Have you had that?
Absolutely.
Absolutely. What can happen then?
Documents, like where I live, you have to own it for 18 months before
Before you can lease it out.
you can lease it out.
And some, you have to, it goes 2 to 3 years I've seen. So, I mean, if you have, as an investor that was planning on leasing it, forget it.
Yeah. Sometimes you have associations where they have a maximum number of rentals. And it looks on the paper like you should be okay, but you reach out to the CAM and you find out that they're at capacity. They're not going to approve a tenant. They're at capacity. And so those are conversations to have as a part of a due diligence. And Natasha, I think you put it right. Make sure that you're having a contingency built into it where the buyer has a chance to review and make sure that things are set up the way for the buyer's intended use. Again, buyer is the North Star.
Just to add to that, we are almost never going to be able to ask every question of the buyer of every possible situation. So making sure that your buyers know that if they're picturing something that they need to tell somebody, because there's nothing worse than getting to the closing table and you're sitting at the closing table and I say, congratulations on your new home. I hope you'll be really happy there. And they're like, oh, we don't plan to live there. And I'm like, well, you just signed a loan for a primary residence, so that would have been handy. And sometimes people don't tell you things on purpose, but sometimes people don't think to tell you. So when you're having those conversations, if someone says something and later you're driving home and you're like, wait, they kept mentioning that iguana. I wonder if the iguana is going to move with them. Feel confident in asking those additional questions because you want to make sure that you're serving them well. And what you'll find is a lot of people don't necessarily think about how that might impact their real estate transaction, especially if they're coming from another state where associations aren't very popular, they're not thinking about, or very common, they're not really thinking about how significantly restrictive some of them can be, or how that could impact the way that they use their property. There's a lot of people who are like, well, it's my home. Once I own it, I can do whatever I want. And it's like, well, yeah, as long as it follows these rules, you can do whatever you want. And so just making sure when you pick up on something that you're able to advise them to either ask follow-up questions or do additional due diligence will serve you well. Because to Alex's point, once you lose their trust and confidence, it's really, really hard, nearly impossible to build that back, and you don't want to lose out on that. I know we're all in the referral business. We want to work with people over and over, not because they don't have a choice, but because they choose us every time. And to the extent that you can give them that additional service, I think it goes a really long way. And if this is not the right home, they know that they can trust you with the next one, versus me getting the phone call that's like, oh, well, we talked about rentals for like 3 car rides and they didn't tell me that I couldn't rent this out, and then I bought it, so I'm never working with them again. And you're like, oh, well,
Yeah.
there's
And
nothing.
maybe suing.
Yeah. Oh, well, I can't believe that didn't come up. And sometimes, it doesn't, but to the extent that you can.
Good. Thank you very much. All right. So you did bring up an interesting point, Natasha. You said, what if you're closing on a transaction and the buyer closes on a primary investment loan, but it turns out they're doing it for an investment process, which sometimes things like that happen in a transaction. Buyers or sellers are maybe a little bit less than transparent. What happens if we have a seller who has heard these whispers in the hallway about the sinkhole full of poisonous snakes? What if we have a seller who does not disclose that there's an upcoming assessment? What are the ramifications for something like that, for a failure to disclose with both condos and HOAs? Are they different? Are they going to be handled differently?
Typically, yes. So we don't see quite as many HOA-related special assessments, mainly because a majority of the things that we see special assessments for in a single-family home, the owner is responsible for. Things like roofs, pool cages, all the fun stuff that we got to experience last year. But generally speaking, the seller's still going to be liable. Again, whether a buyer's really going to go after a seller after closing is probably going to depend on the dollar value of that special assessment. But I can tell you that I've sent several demand letters out for buyers because they found out after closing, because they've been walking down the hallway, meeting their neighbors in the condo building, and they're like, oh yeah, that special assessment really sucks, doesn't it? And they're like, what are you talking about? And it's like, oh, we've been talking about this for months. We had all this hurricane damage, and we know that there's a special assessment. We've just been waiting for the amount, but we just found out yesterday. And then it's like, oh, well, cool. Everybody knew but me. And so those are things where you're going to have a buyer who's like, well, you knew it was coming. You didn't know the exact amount. It wasn't technically pending, but you knew that there was going to be a special assessment and you didn't tell me what it was. And if it's $500, you might have a buyer who's like, it's not worth it. I'm just going to let it go. Joys of homeownership. But if it's $5,000, maybe they feel differently. If it's $50,000, they probably feel very differently. So it's just important to make sure that sellers are disclosing, because that's going to come back to them. And in most cases, buyers are going to want something to make it right because they're undertaking an expense that they weren't expecting. And especially in this market, I feel like we have a lot of buyers who feel like the special assessments aren't really their fault. There should be things that the sellers have taken care of, and they don't like the unknown, and they already agreed to a price, and they're the only buyer out there, so the seller should be so lucky that they bought it. So you're overcoming a lot of that as well. So just making sure your sellers are disclosing, because that's not going to be a fun lawsuit to be part of.
Okay, so one of the things that often has to happen in a condo and sometimes in an HOA is that your buyer has to get approved. But that approval sometimes comes through a board, like it'll come through the board, sometimes goes through the CAM to get back. And either way, there's a process that has to be followed. Approval doesn't generally happen in an hour. Can we agree on that? Yeah, it generally does not. What if your buyer is not able timely, through no fault of the buyer, to get approval to purchase in the community? That there's just a delay?
Well, it depends if it's condo or HOA. And the condo rider, the buyer can get out of in both cases, the buyer can get out of the contract if they're not approved 5 days before closing. The verbiage is slightly different. In the HOA rider, it says the contract the contract may be terminated at the buyer's discretion. The condo writer, it says the contract is terminated. In practice, either way, if your buyer's not approved, they don't have to buy, they get their deposit back. But it's 5 days before closing. Think about your short, quick turnaround time closing contracts. You're typically not getting your approval 5 days before closing. I've gotten approvals while we're sitting at the closing table. So just keep that deadline in mind. Both of them now, when they were revised in, I think, 2021, added language that says that the seller needs to initiate the approval process. So another opportunity for your seller to be really involved is get that application out. I know a lot of people put it in the MLS. They have the seller pre-fill out their part and just put it up there so that way the buyer can go, but make sure that it actually gets read by someone, because I've had, unfortunately, several instances where the listing agent's like, yeah, I don't have to do anything. It was already in the MLS. All they had to do was download it, but unfortunately it got missed. Or sometimes sellers forget that they went through an application process. I've had several sellers tell me backwards and forwards that they never applied to the association. There is no application. And then sure enough, in their file is their application. But sometimes people forget. Sometimes we're dealing with people who own a lot of property and they can't remember which one they applied to, and sometimes the rules change. So either way, just make sure that you have that sellers are completing their part, that buyers are submitting those applications early. If you can convince your buyers not to put it in regular mail and to either overnight by UPS or FedEx their application so they're not lost in UPS or USPS land, that also helps, because I'm currently waiting for an application with a check to get delivered by regular mail someday. we close next week, so hopefully someday this week.
I love that. Brooks?
Well, you also want to make sure that you put the closing out far enough, because in the condo documents or HOA documents, it says how long the association has to approve. And it's usually on the application. So keep that in mind.
I love that. All right, so how do associations typically screen and approve buyers? Like what aside from an application, or is it just the application what are some elements that a buyer might have to go through to get approved to purchase?
Well, fortunately today we have FaceTime and all other resources to do that. I've experienced buildings that have like very transient, where there are no board members available to screen the tenants. So they usually either have a special committee to do it, and then you work with the management company to allow the process to, finish in a timely manner. So I'm always open to communication with the management company, make sure that if I'm the listing agent, that the buyer's agent has received the application and has been given to the buyer, and I continually communicate to make sure that the process is moving along so it doesn't delay us in the end.
So you said something really, like just a little nugget that fell in there, was that you said that when you're the listing agent, you want to make sure that the buyer's filling it out. I think it goes both ways, right? Both the agents should be communicating. If you're the only agent in the transaction, just make sure you're doing it. But be a fail-safe for the other agent and just say, hey, here is the application. Can you make sure to kick this off? Because how many days do we have to apply? 5 days?
You have 5 days to initiate the
To make the
application
application.
process, and then 5 days before closing to be approved before the buyer can cancel.
And so one of the things to do is to provide that very timely, if you're the listing agent, to the buyer or the buyer's agent. And then if you're the buyer's agent, if you're working on the selling side of the transaction, to make sure that you have initiated, even if you're not provided with that application, even if it's not in the attachments through the MLS, to make sure. Most condos are going to have an application process. Some HOAs are going to have an application process, that you're getting that documentation, you're providing it where it needs to go.
My last comment on that will be that some of them do, as Katie mentioned, require interviews, whether it's through FaceTime or Zoom or whatever else. Let your buyers know that that might be something that's happening, because this is, as we get through March or spring break in March and then head into the summer, everybody's traveling, and I've had more than one transaction derailed because someone was on a cruise and wasn't able to do an interview because they didn't have any internet connection or a steady internet connection or whatever that might be. So if that's something and they couldn't get their application in, same thing, things like that. So to the extent that you're working with buyers that might be traveling and hard to connect areas, make sure that they can do some of the stuff ahead of time, or that there's enough time in the contract that they can get back from their trip and then do it, because I've had many an extension because of cruises.
They do have Wi-Fi on cruises. You have to pay a little extra for it.
Apparently my buyers don't want to do that. Apparently they're like, oh no internet. And I was like, I don't know. Every cruise I've been on, I was able to check my emails, but here we are.
That's fun. Yeah. All right. So let's talk about special assessments for a minute, because we are running into a special assessments now. We're running into special assessments regarding the milestones, because we are running into where people have to do repairs. That can create a special assessment. We run into special assessments sometimes because storms cause some unexpected damage that reserves couldn't function. Can you guys explain what a special assessment is? Like, what kinds of things do special assessments cover? Why do they exist in the first place?
That's what I was going to say. Something that's come up, they have to call a special meeting because they need to get something fixed if the elevator breaks. A good example was hurricane damage, extra landscaping cleanup. You know, it could be a variety of reasons why they need a special assessment. And then once that's in addition to your quarterly or monthly maintenance fees. But typically they call to order a meeting, and then, you know, the meeting votes whatever the reason behind the special assessment, and then if it approves, then, you know, that's in addition to all your other fees. That's how it works.
That's it.
Another popular one is insurance. When your insurance premiums go up, I know that I say unexpectedly, like we're not all expecting them to go up every time, but that's another popular reason for a special assessment, is you get that new insurance renewal. It's much more than you anticipated when you built the budget, and now you need each unit owner to make a bigger contribution.
So would you put in your special assessments, is that going to be things like funding reserves? If your reserves are too low right now for the current Sunrise condo law?
Yes, so that's a common special assessment we're going to see now, is getting those reserves funded, because that money has to come from somewhere. And unfortunately, it's all the current unit owners who are going to have those special assessments to help build those reserves that will hopefully, in the long run, make it more sustainable to be a condo owner and have a predictable dues structure.
We got a question?
Dealing with an HOA now where they've raised the dues assessed each year. However, we've never hit quorum. Can they impose that without hitting quorum? Or is that strictly a function of the board and they still can implement that?
So the question is, what an interesting question. So your question is that, you know, the association knows that there needs to be a special assessment. In order to pass the special assessment, they need to have a quorum. They have been unable thus far to achieve a quorum. I'm gonna leave that for our attorney.
It depends. It really does depend on how their documents are laid out. Typically, the condo or HOA documents will lay out what they need a quorum for, and then also, hopefully if they're drafted well, what happens if there's no quorum after multiple attempts. But it should be in there where they have a process where at some point it's going to have to be, oh, well, this gets delegated to the board, because hopefully they're drafted. Typically, when I draft my condo documents, I have it so you make an attempt, but for certain circumstances, you have to let the board make decisions, because otherwise you're leaving everybody in limbo, and that's not fair to the homeowners who are participating.
It also sounds to me like they should probably work on their quorum rules. Yeah, or communication with their owners.
Timing of meetings, maybe. I feel like we deal with a lot of snowbirds, and if you time your meeting wrong, everybody's gone.
All right, so when we have these special assessments, can that affect financing in the transaction? And how so?
It can. Everything can impact financing to the transaction is really the short answer. It really depends. So on one hand, it can impact a buyer or a seller. On the buy side, if there's a special assessment for something that looks to a lender that it could be recurring, and they're like, well, We don't know if all of these are going to get collected, and what position is the association going to be in if everybody says they're not paying it, and now I've financed this $1 million condo that we know needs I don't know, the condo association as a whole needs $500,000 in repairs, and nobody's paid for anything. I don't know if I want to finance that. So you might have a lender who's a little hesitant there if they don't have a good financial position. The other way that it could impact someone is if it's a surprise, your buyer might not have the cash for it. So depending on how you fill out your condo rider, you might have the special assessment either being a seller obligation or a buyer obligation. And I've seen this happen before, you are not thinking about it because you're just not thinking about special assessments like I am all the time. You check the wrong box on the condo rider, or you have a really, really clever listing agent and she checked that the buyer will pay and you just missed it and didn't think about it and moved on. And now the buyer's hit with the special assessment and the buyer's like, well, I don't have $10,000 extra to bring to closing. Or maybe they do, but then it messes up their ratios and how much money they can afford to finance. So it can impact your closing. So just making sure that you're being diligent with that is important. Slightly unrelated, but an important note about special assessments. The special assessment section in the contract, there's a box that says seller will pay all special assessments or buyer. Those special assessments within the contract are for anything levied by the county or city, like any municipality, not the association. The only association special assessments are in the condo rider and HOA rider. I have this conversation with people like once a quarter where someone gets really mad because they want to check a different box in the contract. And then I remind people that there's no county special assessment, so it doesn't matter what box is checked. We're fighting about the wrong box. So just make sure you're paying attention to that, because I've seen people get really fixated on that and going, well, seller will pay this. And then they have buyer checked on the rider. And so now the buyer's stuck paying the condo special assessment. And they're like, but the contract says, I'm like, oh, that's different special assessment. So just make sure you're being mindful of that as well.
Yeah, do you guys see typically pre-populated condo riders placed sometimes in the MLS attachments? Yeah, is that something you guys see? You can just download it, and what do we do then? We throw some signatures on it, and we send it over for the buyer to review, right? Digital signatures. We're not signing it, of course. I don't want you guys to think that I'm signing anything. I'm a broker. I try to sign as little as possible. But so in a case like that, that's where we might see a seller who knows that there's a $20,000 assessment coming up. They might be selling because of that assessment, right? Conceivably. And so they check the box. I don't want to pay it. Buyer can pick it up. Buyer can pay. When's the last time? This is a rhetorical question. When's the last time that you sent someone digital signatures and the buyer went line by line and understood every single thing that they read? When's the last time you sold it to a lawyer? Sorry, Natasha.
Well, it's funny you say that. My husband did not read our contract when we bought our house, so he was the one exception to that rule, I guess.
But he was the one that did that get you in trouble?
Well, he goes, you do this every day. I just assumed that I could sign it because you put it in front of me, which is a lesson to you all that that's what people expect, whether it's your husband, your best friend, your client, they rely on you and they assume that the way that you're going to do it is going to work, but it might mean that they didn't read it, which my husband did not read it because he had DocuSigned it before I'd even opened it. So.
And we're still talking about it.
Oh yeah, I'm never going to let him live it down. I was like, you're the worst lawyer ever. Aren't you supposed to? And he's like, well.
He's a very good lawyer. He's a very good lawyer. All right. So, all right, I think that we have talked about special assessments to death over the course of this. Let's talk about challenging HOA or condo issues. Let's talk about, and maybe we'll make this part a little bit more transactional. Let's say that we have an association that has really high fees relative to the property value. What can we do as listing agents or as selling agents? What should we be looking at and communicating to our customers about what those look like? Like, let's say, for instance, if you have $800 a month fees, how could we explain that to a buyer? These are unprepared questions, guys.
Well, you know, $800 a month is pretty standard. I hate to say in today's world, but I think they need to know this up front, because if they're on a limited budget, they're going to have to anticipate paying that, and maintenance fees and assessments never go away and they never go down.
Mhm.
So depending on the building, what kind of condition it's in, the financial, you get the financials, you make sure it's a strong financial building. And hopefully they won't get socked with any, special assessments or high increased, as a result of insurance, for whatever reason, the barrier islands where the insurance is going up and you're seeing maintenance fees, every year, 2,000 a year annual cost. I think it's across the board. I don't think it's limited to just one building or community.
Yeah.
So you have to have this conversation with your buyer up front that this is reality today after, everything this area has gone through last year.
So that may be setting some expectations and saying, let's run these numbers and make sure that you're going to be comfortable, not just now, but what happens if your fees keep going up 3 years from now? Is this still going to be an attractive proposition for you, or do we want to go look at something different? Is that the advice?
Yes, and another thing, it depends on the property. If they're going in with a mindset that they're going to have to do a lot of remodeling, that's part of the financial component as well.
Mhm.
I mean, in a condo, I hate to say it, but it can be very expensive on the barrier islands. And if you're looking at a condo that may need $100,000 worth of upgrades in the inside, well, make sure you have, the money readily available to do all that.
Yes, we had a question in the back. So I love this advice. So one of the things that I'm just going to repeat out loud for them on this side of the room is that in the event that you have these fees, those fees actually cover things. That's not just money thrown away. That includes a lot of the services. And so you mentioned specifically things like mowing the yard, the fertilizer. Often it can include, depending on the community, water, cable TV, if people still have cable TV or internet. Any of the things that people are looking at that are actual costs. Even if you buy a single family home, non-deed restricted, no association, and all just base property taxes, you're still going to have to pay along the way. And so one of the ways to kind of soften the blow, I think she says, is to explain what those costs go to. And how can we figure out what those costs actually go to?
Well, typically in a condo, they're listed, cable ready, and just utilities, water, could include a manager's salary. It's definitely like the insurance for the building, depending on if it has a boat basin or, golf course. It could be a lot of little extra things, but typically they're listed, so they would know up front. But that doesn't include whatever extras the buyer may want, whether it be add-ons. I used to, back in the old days when it said cable, I would have a buyer that say, I would say, well, that doesn't include, HBO, whatever. That's all extra.
Mm-hmm.
Sometimes reasons, certain utilities, they're included, but sometimes they're not. It's just the way the community was developed. So you have to give them a generalization of what's included, and then they will have to figure out everything else in addition and set themselves up with a budget. So.
And then you have your amenities, and then you get the people that say, well, I'm not going to use that pool, or I'm not going, but we won't go there. amenities. And then if you're on the barrier islands, I mean, a smart consumer would know that's the price you pay
Mhm.
for being in paradise. So
That you can't get that for $200,000? Not anymore?
And another thing that I just know where condos are falling, where it's like one big condo where you have, let's say, different phases. You know, you got a tower, you have like villas and so forth. Well, then you get like the people that are in the townhouses are, why are we being assessed 20,000 plus? Oh, well, the towers need new elevators, but they're all one association. So the people in the townhouses that don't use the elevators are going to pay for it.
Natasha, you want to kick in?
Sure. One thing I will say to that is that's another important reason to review the documents, because some of them are set up like that, where if something impacts one building in a community, everybody gets assessed, and others are set up with sub-associations where all of the high-rise condos are one association and the townhomes are separate and the single-family homes are separate. And that might be something that's important to someone who might be the person who's like, well, why am I paying for elevators? There's really nothing equivalent that they're going to pay for me, so it doesn't really balance out. So that might be a factor when people are making those decisions. But I think really making sure people understand their amenities and also the value that it adds. They might not be the person who's going to use the community pool, but maybe their unit retains value and is going to be more valuable and appreciate more than someone who doesn't have access to a pool, or maybe less. I don't know. I don't want to hypothesize what might happen in the future, but things like that, where they're not necessarily just deciding what's valuable now, but how does it impact their future investment, whether it's truly an investment property or otherwise.
So what we're starting to actually get into here, and I'll come back to you in just one moment. So what we're actually starting to get into here is the concept of multiple associations. For instance, we are right here on the very edge of Colonial Oaks. Colonial Oaks is a single family community, but there are, I think, 8 different phases just within Colonial Oaks with 8 different sets of restrictions. One HOA, I think, but 8 different sets. But we also run into, particularly as we start getting into country clubs, I know that the Oaks was mentioned earlier, we start to see it in some areas of Lakewood Ranch, where you have multiple associations. You might have a master association. You have this in the Meadows. The Meadows is actually, I think, a great example of this. You have the Meadows Homeowners Association, which is probably called something different. And then you have all the different communities, the dozens of communities that are in there. All of them have their own assessments. How do we negotiate? And I don't mean that in a transactional sense. I mean, how do we negotiate just understanding who's responsible for what? Is it possible that we have to make multiple applications? Are there multiple application fees sometimes?
There sure are. There's never going to be an association that doesn't want to take your money. So, and sometimes with multiple associations, there's multiple estoppels that are required. There's multiple applications that are required. I would say in our area, a majority of them have the application process streamlined. So you only submit one application, but they will still take 2 estoppel fees. And typically there's only one application fee. You might see 2 transfer fees, and the transfer fees are typically charged to the buyer to transfer all of the accounts from the seller's name into the buyer's name. I don't know why they need $150 and to charge it twice, but that's a conversation for a different day. So you will see that, and that's important to disclose to buyers too, because I have this conversation with buyers from time to time where they get really frustrated with the association, and then they have to have the hard decision where they decide whether that's an association they still want to live in, or if this is their tipping point and they're like, you know, if they want to make it so hard for me to live here, is this somewhere I really want to live? And that's never a fun conversation. We don't want to get that far. So to the extent that we can do that due diligence upfront, you can always check with your closing agent, because we might know the answer, because if we've closed something recently in the same neighborhood on the same street, we might be able to say, oh yeah, there are 2 applications, or no, there's just one, but they will charge you all these extra fees or whatever it might be. We can get that information from you. Still want to get it from the association, but it's nice to have that as a stopgap, because again, sometimes the information's outdated, even if it might just be a few weeks old.
So this is sort of like the crystal ball section of the questions. The condo associations are experiencing a ton of pain right now, and there's a lot of downward pressure on prices. Things are kind of expenses.
On home prices?
Prices of condos.
Yes.
Condos. And their expenses seem out of control. There's a lot of things that they're challenges they're dealing with. Where do you see the opportunity for that to change? Or where do you see the opportunity for an investor to capitalize on this disrupted market?
So if I understand your question correctly, right now what we're seeing is tale of two markets. We have single family market, which is not doing as awfully as some other areas of our market, namely the condo section of our market, where we have seen double-digit decreases in values now multiple years running. Is that correct? And so the question is, what's a magic number for an investor?
Yeah, if you're servicing investors coming in to try and maybe, because our job is to try and turn that market around as realtors.
That's right.
We need to get in there and try and find the opportunity to try and make it better.
Mm-hmm.
How?
So how do we?
What do you have any ideas of where things are headed? Just, what are your ideas on where things are headed?
We just have to get through all the special assessments because of the milestone and the insurance and all that. That's going to take quite a few years, don't you agree?
Yeah, it's ongoing now for a few years, and hopefully we're closer to the end of it, but it's not right around the corner
No,
either.
it is not around the corner. And then I'm sure you've heard that a lot of big developers are coming in and buying out the condo owners that can't afford it anymore. And they'll tear it down and build a $3 million condo place. So
Any other thoughts on this?
Well, I see it a lot on Siesta Key, and I just hope that it eventually balances out. But definitely, I am seeing a buyer's market. Condo fees just continue to go up. And unfortunately, as the longer the inventory rises and the condos sit unsold, I think the prices will go down a bit. But but being on a barrier island, I think that the prices are going to hold. I don't think they're going to crash. Anything near the water usually holds its value. But I am seeing them going. I've seen quite a few even drop to $200,000 that were overpriced to begin with.
So I think this is a great question for the room. I can kick in on this too, but is yours a question or a comment on this? All right. And do you have comments on this? Or is it a kind of a newer question? All right.
Let's hear your comment.
Well, I've got a comment here and then I'll kick. So I think, and that's a great comment. Thank you. So I think that over the course, as we look at the second half of last year, we saw Debbie, Helene, Milton. Before that, we had the Sunrise Condo Law, which is now we've got the assessments that are going up. Of course, we have a market that's been kind of slower than a lot of people, a lot of sellers in particular would really like, certainly that a lot of realtors would like. Those are things that we've been running into. At some point, people remember that it never snows in Florida, except for this year, right? Except for this year. People remember that. And I think that people tend to recover. If we look at some of our other areas in the longer run that have been hit harder, if we look, for instance, at Fort Myers, which was unfortunately just devastated in Hurricane Ian, they've rebounded completely. At some point, I think prices come back because, Brooks, I think you actually hit it on the head. At some point, all the condo, those rising fees, they do equalize, or they at least stabilize. I don't know, they're not going to equalize, but they're going to stabilize. And they're going to be at a new level when you used to be able to get into those for a few $100s, but then have special assessments that nobody really talked about. What I think is going to happen at some point is, and that you're going to be looking at with investors, is you're going to be looking at ROI on money spent. Because your investor doesn't really care what they can sell it for, they care about cash flow. And if you get your cash flow, your profit from that cash flow high enough, it kind of doesn't matter what the purchase price is, as long as it's in bounds, right? As long as it's feasible for them. They're looking at the spread and then to carry it over time. And so I think when you're looking at those transactions, where you start to find that for your investors, the investors are going to be the ones who actually find the bottom of the market, because that's actually the renters who are going to set those bottom sale prices. And that's what we see in big condo markets where we're seeing some of that. Now, this issue is not exclusively on the Keys. We're seeing that all over the place. In fact, we're seeing that at associations even that aren't affected by the condo laws because primarily insurance. So kind of in a way, it's kind of all just tied together. Regardless, prices are going to go up at some point. At some point, we are going to find a floor. You will never, ever know the floor until you've passed it. All right? The truth is that people are the best money for an investor, the best purchases are the ones that happen before we reach a bottom and before buyers understand that we've reached a bottom. Because what happens at that very bottom is feeding frenzy. And now what you have is you don't have those sellers who are willing to look at the $200,000 less than ask. They're just not interested because now they've shown their property to 14 different buyers. What do they have again? Hope. That's what they have. And so for an investor, I would think that in a market like this, understanding that at some point we're going to turn. At some point, people want to return to the great state of Florida because sunshine, because low property taxes, because of any number of reasons that people want to live here. We have really great sports teams. Come for that. They're going to get here, and they're going to turn around. And so my conversations with them, don't look for the bottom, look for your spread, and then go find them their spread. And make offers while you can make offers. Because when the bottom comes, you make whatever you want, but you're not going to get them anymore. Okay? The aggressive buyers are the ones who take risks. Those are the ones who make most profit in the longer run. Okay? Thank you. Thank you, Donna. I love that. We got a question, her hand, then his hand, and then we'll come back over here. In terms of specific communities or in terms of features of the associations? What should be, okay, so now we're talking about maybe in commercial, we might be talking about a smaller association, right? We might be talking about a condo association of 8 little places.
The most current that I've sold warehouses that had a condo, I was told to just directly go to the management company. They were slow responding, but I finally did get all the information that was provided to me that I shared with my buyer. I mean, you don't have a lot of emotion and with commercial properties, and they're not worried about the flower beds and all those things. It's just basically the paving, the ingress and egress to the property, and it's pretty standard stuff.
If your specific owner, tenant has any unique requirements, whether it's power requirements or medical waste that needs to be disposed of, things like that, just making sure the association has something in place to address that, or has flexibility in their documents where they don't necessarily have a fixed policy and they're like, nope, that's your responsibility. You handle it, however you want to. So that way you're complying with those requirements. But usually the commercial condominiums tend to be, have fewer restrictions because they typically want each unit owner to be able to manage their unit, and they're really only there for the common areas and typically address parking, paving, roofs, things like that, probably minimal landscaping, but for the most part, they put that on the individual commercial unit owners.
So ask questions and find those are going to be a little bit more specific, I think, is the long and the short of that. A question here? So the question, again, just for the room, is that, so if we're looking at, the concern is that if we're talking about the older condos, where we're seeing kind of those costs that are doubling, sometimes sometimes more than that. If you look at new construction where they've kind of already factored those in, and they're not really applicable anyway because it's brand new construction, are we finding a better opportunity or more stability in cost there?
Well, with new construction, definitely with insurance, because everything is built up to the codes, new codes and so forth. I think it just depends on the community.
I agree. I think we see a lot of people who are really, especially out of state, who are really interested in new construction because they seem to have the peace of mind of it being built up to new building codes versus having to go back in and retrofit something. So you might see people who are interested in that. I think also in our market, we have to be mindful of the price point of our condos. A lot of our condos are much more, the new condos are much more expensive than the more affordable older condos that we have. So knowing your buyer and their price point is going to make a difference there as well, because you might have someone who goes, yeah, I want a new condo, and I can't think of any off the top of my head, new construction condos that you can get at our average sales price. So it might just be also knowing your buyers and what they're willing to invest in.
I think another concern when you're looking at new construction is that sometimes what you run into is that builders subsidize their HOA fees while they're building it so they can advertise lower costs. And then what'll happen is that during the course of the build, their fees are relatively low because, for instance, they might not have to pay for a community manager or a recreation manager. They might not have to staff the Bahama bar that they're getting ready to build. No offense to anybody who has Bahama bars, which I know that's actually pretty popular. I should use a different example. They might be only mowing a small section of the community right now and letting the rest of it grow because they're just taking the green belt on that part of the property until they get ready to go build into that phase. But at some point, they need to expand the landscaping services. And so when they turn everything over to the association, sometimes associations run into a headache because now they have to go back and say, wait, we can't actually afford what we have. How do we fix this? And how do we fix that?
And I can attest to that. There typically is an increase on new condos. I see this on the ones that we close for developers. Keep in mind that when your developer's budget set, they're building that budget before they start construction when they're advertising it. And so you're looking at maybe 18 months, 2 years, sometimes longer. Even if they estimated everything perfectly, the cost of everything is naturally going to go up in 2 years. So you might have someone who's like, oh yeah, we can do this for $500 a month. And then 2 years later, when you're closing, you're like, oh yeah, but like natural cost increases, it's actually now $800 a month. So just because a number looks pretty on paper doesn't mean they're going to be locked into that, because to Alex's point, they haven't actually done it. There's no track record that that's feasible yet. It's still just good on paper.
Yeah.
And most of the documents tell you, assuming that your buyer reads them thoroughly, that they can change. But again, it's usually, on page like 57 and no one gets that far.
Yeah. So what you want to look at then, especially with the new construction, just look at costs and make sure that your buyer is aware that that's something that can happen. And that also, by the way, this isn't really the association question, but buyers often in new construction do get hit with higher property taxes the second year because taxes are done in arrears as of January 1st. So if you close October 31st and your property taxes are $1,200, that does not mean that because you got your CO in 2025 instead of 2026, which is another reason why the way to push closings into January, is that what you might really be looking at is you might see a several $1,000 jump just in taxes through new construction. Yep.
The developer does have to build in reserves into their estimate, so that should already be included. They changed the law, I think, about a year and a half ago because every developer that has ever existed opted out of funding reserves because why would they fund reserves if they didn't have to? But the rule changed and they are now required to fund reserves. Oh, that's okay.
No, see, but this is good
But
news.
now everybody knows because
And-
it was something I meant to mention.
That's right. I didn't know that, actually. This is news to me as well. But it's a great comment because it also gets us thinking about just looking towards the future and looking and saying, let's understand where we think that these are going to be. And to the point of looking at residential multifamily or to look at investment property or to look at existing resale properties, that gives you, if they've already reset on a lot of their fees,
caveat
gives you
is
an idea of where you have a stronger idea of where those finances are going to land.
caveat is that when the law changed, it's not retroactive. So if there were projects already in progress, they weren't required to go back and make changes. So for probably the next 18 months, you probably still want to double check the budget to see if they've included reserves or not. But they should be able to provide a budget that specifically says either it includes reserves or not. So
I love it. Did I have another question over here? Yes, I did. That's all right. This side of the room had to catch up a little bit.
I've always used the rider. I've not used the addendum typically. What should we be doing? Is the rider enough? Is it about the same info? And the addendum is on another page longer, I think.
I believe that it's only the rider that attaches to the FAR bar contracts. I don't think the addendum, I think the addendum might be for the CRISP contract. So it has similar information, but is meant for that contract. Basically same information, but I would use the rider. I think condo is rider A and then HOA is rider B.
And you
But-
might have both in a case of a master.
Yes. Earlier was the condo addendum.
This weekend when I made and the agent didn't have a rider. I'm like, hey, I need a condo rider. I went in and I went search condo in my document. And get a blank one.
I'll have to look that up because I'm not familiar with that document. It might be the attachment for the CRISP contract because I think that contract references all its riders as addenda, but I rarely use that contract, so I can't.
Yeah.
Yeah, if you
You
use
have-
the rider, you're good.
There are three major forms that are available to us. We have our FAR bar standard contract for sale and purchase. We have our FAR bar as is purchase and sale, which are, they're the same general format, but major changes between them, but the same general format. But then you have the CRISP contract, the CRSP. And I, as a real estate broker, do see a lot of confusion just because they just don't realize that it's really, they might be using an addendum for a different thing. And I do think that, like Natasha said, that's likely what's going on here. So just look and make sure, down at the bottom especially, where it's like so small that like I've reached the age where I have to put on my readers, but there it is. Yeah, I do. Yeah. All right. So let me ask a question here. We talked a little bit earlier about providing documentation. I promise we're almost at wine and cheese, guys. As soon as they give me the okay in the back, we're going to wine and cheese, but they're not quite there yet. So we talked about how to get association documents, and that sounded really easy until we start talking about things like Colonial Oaks, where we have 8 different phases. That honestly, here where we are, single family community, one association, 8 different sets of restrictions. And it is truly, that is the way that it is in Colonial Oaks. If you go search on our county clerk of court, on our comptroller, and you just look up the restrictions for Colonial Oaks, going back till the 70s when a lot of these homes were built, you might run into hundreds of pages of different, sometimes irrelevant rules and regulations, often addenda or that they've made amendments to over the years and then have unmade amendments to over the years. My question is this: is that the Realtor's role to try to sort through all of that to provide the buyer with the best information? Is it?
I'm a firm believer, be a source to the source.
Thank you so much. Be the source of the source. Okay, so, do,
I was going to say something similar. It's you want to be a resource, but you don't necessarily need to be the person who's giving them a document, and you don't want to create, you could tell I'm the lawyer, you don't want to create liability for yourself by providing them with 3 documents and saying this is it, because you can't control what else might be out there. But you can tell them to call me or call whoever your closing attorney is, and we can pull them documents, and we can do a more detailed search than just typing that into the public records and seeing what comes up. Our underwriters can pull documents for us, and we can provide that to them, and that takes some of the liability off of you because you're not downloading something and giving it to them. Or you can tell them to go in the public records and take a look, and they can do that. But to the extent that you want to give them something, that might be a better option to insulate you from a little bit of liability. I have unfortunately seen a significant increase in the number of people who want to sue other people, typically for things that don't really make a whole lot of sense. But when people are angry, they're angry and they want to burn it all down. And I have the fun job of trying to dissuade them from doing that. And one thing that helps is being able to say, well, they did exactly what they were supposed to do. Nobody did you wrong, or, you know, it wasn't that you were unhelpful. It's you did what you were permitted to do or provided a resource without necessarily getting yourself in any kind of trouble.
I love it. All right. So one of the things that I look at as a real estate broker is I try every way possible to not get sued. Like that is like my number one goal. I wake up in the morning and I'm like, what am I not doing today? Like exercise and getting sued. I pick 2. And so, so what I look at though is that I want to try to get the information from literally any source except me going to track it down if I can. And when it comes to what are the rules, I really love this. Please provide the most, and to place this in the contract so that the seller has an obligation to perform, to say seller will provide the most, the current list of restrictions, to place the budget, and have the seller go figure out what that information is and have them bring it to you, so that all you're doing is you are sourcing the source and you're just a conduit. You received a document, you passed that document, you never claimed that you went out and got that document. Who got that document? If that document is wrong, whose fault should that be? Should be the seller's fault. That's my thought. Because I would have a very hard time going through 19 pages, going back to the 1970s of restrictions and amendments, most of which are really boring signature pages, and some of which I can't even read because they did it on a typewriter, and I don't read that font.
And it was scanned so long ago that nobody can read it because it's just a bunch of dots and lines.
That's right. But how cheap were the doc fees back then? The doc stamps.
Do you know how many times I've asked the seller or the owner for all those documents, and they send them, but they're like the original ones from when they bought it 20 years ago. That's what they have.
I know. It's a challenge, and we want to make sure that what we're getting is accurate. And I do think that you have to have an element of expertise and trust in the documents that you're getting. Work with people that you trust, who know. There is something very important or something very helpful about working with people who know the community and who are experts there. Geographic competency is critical. Colette, did you have a question? Sure.
Yes. So the deed restrictions are enforceable because they're built into the actual deed. And so once you put something into the deed, it becomes a condition of property ownership. So Southgate is an example of that as well. Voluntary HOA, you don't have to be a member. You can be a member, and if you are, you get access to the community center and the pool. But if not, you can continue to live in the neighborhood, no big deal. But all of the rules and restrictions of the neighborhood still apply to you, whether you choose to be part of the association or not. Is anybody really actively patrolling any of these restrictions? Probably not. But for example, they have deed restrictions on where you can build. So you can't really build into your setbacks because they're part of the original deed, where you said by accepting the new deed, you accept all the terms and conditions. And one of the terms and conditions is that you wouldn't build closer than 30 feet from the back lot line. And not everybody pays attention to that, and they're very good at drafting variances for us. But those rules technically do still apply, even if you're not part of the association. So if that is a deed restriction, I haven't seen that. If it's an association restriction and they're not part of the association, then there's nothing the association can do. But if it was part of the original documents for the community that are in the deed, then theoretically the association could enforce them. They could do what they would do to any other property and send them a demand letter, tell them to stop doing it. And if they don't, they can put a lien on the property and fine them. But again, it really depends on the neighborhood and whether they're going to do that. And also if the property is located within the city or county, that might be an issue as well. If it's in the county and they can't do short-term rentals anyway, that might be another avenue for enforcement, because it doesn't matter what the community rules are, the county doesn't allow it. Code enforcement would be happy to assist them.
So yeah, just to clarify, because it came up, is that if you have a voluntary HOA, I should have repeated it back, but I'm going to give the whole thing in like 2 sentences, and then I'm going to open it for questions, and then it's wine and cheese. But any questions you have, please ask them. So the question was, what if you have a voluntary HOA? You do have deed restrictions. It is bound by deed restrictions, but that home is not a member of the voluntary HOA. The answer is that although it's part of the voluntary, that HOA still might have some jurisdiction over the deed restrictions, and they can raise a complaint. Is that correct?
Yes.
Yes. Well, that was short and sweet. Thank you. That was super short and sweet. However, it is also true that in most areas of both Sarasota and Manatee County that there are restrictions on short-term rentals, and those have to do with really Sarasota County code. And it is entirely possible, we could talk about it after, and in your community you might want to look at it on what are the minimums in the jurisdiction, because then it's not an HOA issue at all. Now you're dealing with code enforcement. And do you know who has more teeth than HOAs? Is code enforcement. That's exactly correct.
Comment on that though is that I went to, for an investor, I went to the county, Sarasota County, and I talked to a county, I don't know, code person, I don't know what their title is.
Yeah,
But
we'll go with that.
I asked them, hey, we're looking at these series of addresses. Are we allowed to do short-term rentals there? And this county person basically said, well, technically no, but lots of people do it and we don't really enforce. That's what they said.
I'm really shocked that the county would give an answer like that.
County.
All right. Well, then let me ask you this question as a real estate professional. Let's say that we're in your shoes, and we're just going to take it to a next logical step. And so you have received a question, you have received an answer just like this from the county. Hopefully you got that in writing, but even if you didn't, you did not.
So he heard it.
All right. All right. Yeah, when dealing with the county, try to get everything in writing. The beautiful thing about corresponding with the county is if you go through their website and you submit to them in writing, they will always reply you back in writing. And then you have something really, really beautiful called paper trail, which is just wonderful. But now what happens is that you hear this, and then county, 6 months from now, we have a new enforcement officer who comes in, and he's the new sheriff in town, and he says, nope, we're cleaning this right up. Whose fault is it? Yeah, not mine. No, because I got it in writing from the county. That's my thought. Okay. Any other questions here? Oh, yes. All right. We're going to go. That was exactly the same time, but we're going to go you closer.
What do they have to put in there? And is that tied into condo and HOA? Or any familiarity with that at all?
I am generally familiar. I haven't looked into the requirements yet. I know that they now have that online portal because I am on an email chain with a lot of condo and homeowner association attorneys who are excited about it because they're hoping this will prevent 500 of us calling their office every day asking for documents because there's going to be one central receptacle for everything. My understanding is anything that all meeting minutes needed to go in there, as well as the original governing documents, amendments, things like that. So theoretically, everything should be in there, but we'll see how that actually rolls out. hopefully they'll put everything on there, because if it's getting recorded, then I might as well just go look in the public records. I really want access to all the stuff that doesn't get recorded that's important. So I'm hoping that's where that will live. So that way it'll streamline the requests that they're getting, because I know from speaking to attorneys that deal with this on a daily basis on the other side of the transaction, they're like, yeah, we get your requests, but we got 100 of them because we have 5 units and all these people interested. And every time a buyer's interested, their realtor sends us an email and asks us for everything. And so, I mean, I get that, but the simple solution is a portal where I can log in and get the information that I need. So hopefully that'll make it more productive, but we'll see.
Fingers crossed.
Associations or communities that were severely damaged. The recon people came in, and even if the owners weren't there, the properties were at least remediated, with drywall removed, and the contractors are putting a general lien on the entire community. So what can a seller do if there is, I'm just gonna make up a number, a $500,000 lien on the community association?
Does a community association lien, a mechanic's lien against a condo association because they are working on big buildings or docks or just a big scope of work, and we called it a $500,000, if they have this, how does that affect a seller?
So, yeah.
How does it affect a transaction? Uh-huh.
The buyer having to pay the whole $500,000 to remove the lien.
So typically the buyer's not going to, or buyer or seller's not going to be responsible for the whole lien. If it's filed against the association property as a whole, typically we can get around getting payment for it by getting an affidavit from the condo association that says that they have sufficient funds to pay it and that there's going to be no special assessment related to it. And if they can do that, then nobody has to pay it off. We're able to close without collecting any funds for it. The issue that we sometimes run into is typically it's hurricane damage related, and typically there's a special assessment. So the condo association's like, oh, sorry, I can't sign your affidavit because I can't certify that this unit's not going to be responsible for any payment towards it, because it might be, but I also don't know what that amount is. So sometimes there needs to be a little bit of closing process negotiation between whoever your closing agent is and their underwriter to figure out what they'll accept, because we might just have to modify that affidavit. It might be we have enough money to pay it, but if there's a special assessment, our buyer agrees that they're going to be liable for this future assessment, or the seller is going to be responsible for the future assessment, and we know that it's not going to be more than $5,000 per unit, and we're putting that money in escrow, so we know we can close. So they're never going to be in a position where they have to pay it all, but from a closing standpoint, we're going to want to know that someone can pay it all, because otherwise that's going to obviously impact the buyer, who's going to move in and then suddenly be like, wait, so I paid $500,000 for this unit and now I have a $500,000 lien. We don't want that. So it's really just making sure funds are available, and on a case-by-case basis, figuring out what makes sense for that situation in terms of who's going to pay it and how we're going to get to the closing table. Several times. Yep. Both my examples were from a couple of weeks ago, where one, the buyer's like, it's already factored into my purchase price that I'm going to pay for whatever comes up, because we know it's going to be, we have heard through all the neighbors that it's going to be somewhere in the like $3,000 to $5,000 range. No big deal. We're going to take care of it. And I have one very, very trusting buyer who's like, oh yeah, the seller, when I get a bill, the seller's just going to pay it. I'm like, are we going to put money in escrow? Are we going to, no, they're really nice people. It'll be fine.
Sure.
So next time you see me, if I'm sobbing, that's probably what I'm crying about.
I love that. All right, guys, any last questions? Yes.
That's fun. That's happened to me too.
Let's repeat that for the room. So what happens if an estoppel letter is issued, then a special assessment is levied, and then the closing is supposed to occur? Oh, but if these things happen.
These things have happened, and they have happened to me. I'm really lucky. As you can tell, really, really lucky. But typically in those situations, technically, the association has an obligation to provide an updated estoppel letter if any of the information gets updated. They really hate when I remind them of this, but the association also can't hold any fees against someone if they fail to put them on the estoppel. So they're really, really good at getting you the updated estoppel. The downside is sometimes it's the morning of closing and everybody signed and you're about to hit the close button and then it comes in. And thankfully in that situation, we were able to get the seller to pay it after closing because they knew that they would have been responsible for it and they didn't want a lawsuit. So sometimes it's the timing of it, but I always tell people, and I do this for myself, I make a note when I see on the rider that there's a pending assessment or that they've talked about it. I make myself a note to ask the listing agent closer to closing if there's been any updates so that they can check in with the seller about that, or with their permission, check in with the seller. I try not to freak out the buyers and sellers when I can. Apparently when I call people, it's terrifying. I don't know why. So that's typically the association will give you an update, but generally speaking, if it comes in based on how the rider is written, it might still be a seller's obligation. And just because we close doesn't mean the seller can just move on and not pay it, even if it's discovered minutes or hours or even a day or two after closing. If you're really unlucky, like one of my buyers, the special assessment will get passed at the meeting that happens 3 hours after you close, and then they'll get stuck with it. But unfortunately, sometimes that happens too, where they hadn't talked about it, wasn't on the minutes, just they walked into their first association meeting 3 hours after closing, like a 7 p.m. meeting. And I get an email and they're like, Natasha, we've been here for 10 minutes and now they want $10,000. And I was like, oh.
Oh, that's brutal. All right, we have time for one more, and then don't leave because we absolutely have, it looks like a great spread back here. You guys are looking at me. I'm so sorry. It looks way better back there where the wine and cheese is. And a drawing, actually. Yeah, why don't you come up and we'll do the question while we're waiting for Charlotte.
On that note, one comment I will make is a standard is for something that the seller knows or should have known for special assessments. I've had several sellers say, I don't open my mail or I don't go to the meetings. That's fine. Nobody requires that they do that, but they're going to still be treated as if they read them and were there. So if for nothing else, they should read them prior to closing so they could be prepared to at least fill out the rider correctly.
I love that. All right, guys, thank you very much. We're going to, all right, let's do it this way. First of all, I want to thank, I think all of you guys are members of our professional development committee. Is that right? Yeah. So thank you guys very much. This was a great panel. I appreciate that. Then we're going to do a drawing. What are we winning?
$25 Amazon gift.
All right, $25 Amazon gift card. I love it. Let's shake it up here. Am I drawing? Is that right? Margie Kraft. There you are. I love it. I love it. All right, guys. Wine and cheese, lots of good times to be had. Let's do it.
Tag teamed it. Oh my God. Nice to see Krista here. Yeah. Who's the one next to her? She in your office? Yeah.
Jennifer Russo.
Oh, okay.
They know Jim.
Ooh. I'll have some wine, damn it. Huh? I'll have some wine.
Yeah, you don't have to go home to Mr. Jim.
No, I need more for that.
How long is he gone?
Till the first.
Oh, wow.
Nice.
Yeah. You don't